Now, I think a lot of HR people probably know that you can go to some external parties or third parties to get this sort of information, and generally that shouldn't be a big issue if information collected by the third parties are genuinely wide enough on a no-name basis and wouldn't have the effect of distorting competition. However, the guidelines had also specifically mentioned that if you put someone in the middle to avoid contravening the competition ordinance, then that is going to be not acceptable. So basically, if you wanted to get information from a third party and you sort of think that, or maybe I would contravene the law, so I get an agent or somebody to do it for you, that is not going to be acceptable. That is not going to actually get you around it. But if you do it genuinely, i.e. If you say, look at a publication which has a wide enough base when they do the survey, that's probably going to be acceptable. The guidelines actually go so far to say that if somebody imposes certain information on you and you believe that information and you have reasons to believe that information could potentially attract a contravention of the competition ordinance, you actually need to tell that person that you don't want to have that information. So this is how strict the guidelines are. But as I say, I think people would need to be quite sensible as to what extent this would actually apply. Some of the exclusions you mentioned are that if it is necessary to protect certain economic interest of the parties, then it is actually an exclusion. Let me give you an example. If there are two companies have an agreement to potentially acquire the other company, so usually, for example, I want to acquire a target and I get information from them, and then I actually ask them to sign an agreement to say that, hey, you can't poach my employees or you can't disclose information, etc. Those would not be in contravention of the competition ordinance, because you're protecting a legitimate interest and it is in furtherance of an economic interest. So that would be fine. But if two companies per se decides, as a matter of general principle, I'm not going to poach your employees, you're not going to poach mine, that is going to be something which will get you into trouble under the competition ordinance.